Nakawa Court was fully packed as Magistrate Deo Sejjemba read out his landmark ruling, dismissing the application seeking to compel the government to disclose the details of the oil exploration agreements in Uganda. The petition was filed by Charles Mwanguhya and Angelo Izama, both journalists with the Daily Monitor. They cited the Information Act and public interest as sufficient grounds to access the secretive oil agreements. However, in his assessment, the magistrate ruled that the applicants failed to demonstrate whether disseminating such information in the media would be for the benefit of the public interest. He based his ruling on international agreements, citing cases in Iran and Indonesia that do not divulge such information. He finally dismissed the application and said it lacked merit.
We're going to apply for a typed copy of the ruling. We'll study that ruling, and after studying that ruling, then that's when we shall decide whether or not to appeal.
We haven't lost hope. 30 million Ugandans cannot be just a number. 30 million Ugandans, the oil prospecting and exploitation agreements that we are seeking represent the interests of the 30 million Ugandans today, their children and their grandchildren, because they will be affected in one way or the other.
But what does this ruling mean for the Access to Information Act?
This presents one major roadblock of all Ugandans who want to access information in the government domain, because it's going to be used as a reference point for government officials to deny access to information. Yet there is a law that says we should have access to information. Secondly, is that it helps reinforce the government secrecy with the oil companies that are exploring for oil and are going to exploit for oil in Western Uganda.
It remains to be seen whether this initial setback will mean a final blow to these journalists who believe Ugandans have a right to access information of public interest that is in the hands of government. Hilary Isiga, NTV Tonight.